Afternoon to all, and a very warm welcome to the fifth session of the webinar series, A Career in ADR and Insider, hosted by the Center of Mediation and Conciliation and Center for Alternate Dispute Resolution, RGNLU. The aim for today's session is to understand what negotiating is, with an added emphasis on the nuances of negotiating for your client. And it is an absolute pleasure to have Senior Advocate Mr. JP Sengh here with us, who, alongside his career in litigation, has also added negotiating to his list of expertise. Sir, it is an absolute honor to have you here with us.
Thank you. Thank you, Krishan.
Before we delve into what negotiating is and all the nuances of the process, I think we're all keen to learn what prompted you to take up ADR and get so deeply involved in the entire ADR process, in the entire ADR field in the first place.
Krishan, our journey in mediation started in the year 2006, when we were first trained at the Delhi High Court Mediation and Conciliation Center. So far as ADR movement is concerned, now I suppose you are referring to ADR, so far as I'm concerned, as mediation.
Right.
Okay. So far as the ADR movement was, in US is concerned, it was promoted in the 1970s. It was a pragmatic search for resolution of what was defined as litigation explosion. The call to settle and to mediate disputes was perceived as undermining the humanist aspirations to protect rights and encourage conscious raising through legal decision making. Some thought this was basically denial of access to justice. So far as India is concerned, ADR in the form of arbitration has been institutionalized in India as an arbitration. It was part of Civil Procedure Code 1908 before Arbitration Act 1940 was promulgated. Now, the way arbitration was conducted, I just want to quote Justice Desai in the matter of Guru Nanak Foundation case in the year 1981. He said, and I quote, "The proceedings under the Act have become highly technical, accompanied by unending prolixity, and an informal forum chosen by the parties for expeditious disposal of their disputes has, by the decision of the courts, been clothed with legalese of unforeseeable complexity." So, looking at how the arbitration was conducted, there has been a movement to transform the judicial system to include various other mechanisms and alternatives to adjudication. Now, in India, there was an amendment to Section 89 in the Civil Procedure Code in the year 2002. Now, it brought in the concept of mediation as a tool for conflict management and dispute resolution. See, mediation has been actually also in Section 30 of the Arbitration Act 1996 mentioned as one of the methods which an arbitrator can use, but it was never used in India. As I told you, after our first training in 2006, what fascinated me was to see how a mediator who claims no authority, unlike the judge or an arbitrator, can help the parties to give order and coherence to their relationship. It was then that I realized that there are circumstances in which the parties can dispense with the outside aid or some kind of authority, like the judge or an arbitrator, and give social order directly out of the interaction between them. And this was something, a great revelation for me. Primary concern of mediation is relationship between the parties, which, let me tell you, cannot be regulated by rules. the central quality of mediation is thus its capacity to reorient the parties towards each other, not by imposing rules on them, but by helping them to achieve a new and shared perception of their relationship, a perception that will redirect their attitudes and dispositions towards one another. So they completely change. I found that mediation process is a powerful tool for satisfying the genuine human needs of the parties to individual disputes. See, for me, this was a shift towards a totally new relational paradigm. Now, this was referred to by Bush and Folger, who talked about this in transformative mediation in 1994, which transforms individuals and in turn has the ability to transform society as a whole. Now, these authors look at dispute not as a problem, but rather an opportunity for growth and learning. See, the threshold training that we got opened up the doors into a magical world of mediation. The more I read and also participated in the AR discourses, I came to realize that we always consider conflict as an anomaly needing to be settled. That's what we thought about conflict. That's a negative perception of conflict. Mediation completely changed this. However, earlier I viewed conflicts as and conflict resolution. And, our bar in Delhi was up in arms when this movement was started. They perceived ADR as alarming drop in revenue. They thought if all cases get resolved, what will happen to us? I saw the shift from finding efficient solutions to empowerment of the parties. I saw parties really getting empowered through the process of mediation. Mediation autonomy, to me, is concerned with connecting with other human beings. It requires cooperation and collaboration with other persons whose values may differ. Mediation is not the method to preserve legal rights and to balance power relations. We should try not to capture it in terms of rights and outcomes. Now, that's the domain of courts. It was this recognition that moved me from acting like a pragmatic lawyer, which I was trained over the years, and learned to believe that parties can learn much more about themselves and feel empowered to handle their own disputes, even in those worst moments, but with the assistance of a third neutral party. But they could do this out of their own volition. So therefore, my outlook to litigation was completely changed. I found our role was not to try and solve problem, which appears on the surface as same as never the real problem. There was this urge to move from settlement in favor of improving relationships and promoting harmony that moved me towards ADR. In fact, the courts have not adjusted rapidly to the social change and the demands of modern business litigants. So here I am.
Yes, so that's definitely very interesting to hear about how litigation explosion led to alternate means being formed, and then how arbitration became too complex, which is why it wasn't sustainable. And then, yes, as you rightly pointed out, mediation does give that human touch, and it helps really preserve relationships, because at the end of the day, we humans, we are social animals, and relationships to us are very important. But sir, I think moving on, I'm curious to understand how you would define negotiation. What is negotiation to you personally?
See, negotiation in very common parlance is referred to as a to and fro communication with a desire to achieve a goal. See, the goal can be compensation package for a new job. It could be custody rights in a divorce. It could be the selling price of a new house. In fact, people sometimes, loosely refer to negotiation as bargaining. In fact, bargaining process is subsumed in negotiation itself. So, we are always, negotiating every day of our lives. and in every kind of situation, whether it is a boyfriend, girlfriend deciding which movie to see, a husband and wife deciding which city to live in, a customer looking to buy an automobile, or an employee trying to get a raise. To me, the goal in negotiation is not to destroy. You see, because it's not a contest. It is not to destroy the other side. The goal is to find the most profitable way to complete a deal that works for both the sides.
Right. So that's very interesting, because bargaining, as we see all around us in marketplaces, etc., it's a competition. Who can get the most, and the other person gets less. But as you rightly pointed out, negotiation is not a contest. Both parties should win. So it should be a win-win situation. So, which brings me to my next question, which is, what would you relate negotiation to? An art or a science? Because of course there's a little bit of um, uniqueness in every negotiation, and every mediator has a certain unique touch. And then of course there's certain involvement of numbers, so there's a scientific aspect to it too. And I ask this because there's so many books that have come out by great authors such as William Ury and Roger Fisher, who released or published the book Getting to Yes. Um, they have a slightly broad structure of how a negotiation or mediation session should go, which does give it a slightly scientific structure to it. But how would you perceive negotiation as?
See, let me first tell you, now that you refer to as bargaining. No, what we do at a marketplace is termed as bargaining, which is actually an act of seeking, as you rightly said, that economic advantage. Seller looks for a higher price for his ware, while the buyer wants the money to last longer. That's what happens in the market. We all negotiate, but many of us have a fundamental fear of negotiating. The fear can make us meek, and we are likely to end up with our goals unmet. You need to practice dealing with fear. That's the first thing. Most negotiating is like a tap dance on the edge of a cliff. If you allow fear to fill you with anxiety, imagine it can paralyze you. You're wanting to dance, and then there you are. And if you let the fear fill you, you will be paralyzed. And this is exactly what happens in negotiation. We've had some trainings where we have had senior chartered accountants who are very, very senior people, when they sat on the seat of as a mediator in the role plays that we do. After the opening statement, the person tells me, "Sir, I don't know. I'm totally blank." So therefore, when you rightly said that, it's a science. There are methods in which mediation is to be conducted. Now, let me tell you, negotiation is just like the game of chess, which goes by a set of rules. You must know and learn those rules. It is only then you can make your moves. As a thumb rule, remember, all negotiations involve an exchange of value. The focus in negotiation is on creating value. Negotiation, as we said, is a two-way street. It is a process that involves not just claiming value, but also creating it. Now, what is value claiming? Value claiming is referred to how value is distributed in negotiation. People have a tendency to jump to bargaining or asserting their positions as soon as they arrive at the negotiating table. When we begin with parties making their claims in negotiation, we are actually trying to distribute the value of a fixed pie. Value creation happens when solutions are found that benefit both parties, or at least one of them, without making the other worse off. The object of negotiation is a win-win solution. You exactly said that. Now, let me explain this to you with an example. See, there are two people in a library, they were fighting. And this librarian, hearing the commotion, goes up to them and asks one of them, "Sir, what is the problem?" He says, "I want this window next to my table closed." So he goes to the other person and says, "Sir, may I understand what ails you?" He says, I want the window open. Now, if you look at this, in a situation like this, when there are two totally opposing positions, you would think that there can't be a win-win solution to this situation. Now, this librarian was a very wise old man. He goes to the first man and asks, Sir, why do you want this window closed? He says, look, I'm working with my papers on the table and there's a draft of wind. As it comes in, it blows my papers and I'm finding it difficult to study. So he goes to the next man, Sir, why do you want the window open? He says, look, I feel suffocated sitting here and I want fresh air. Now, what does this librarian do? He goes to the next room, opens up the window and comes and closes this window. Now, there is no direct draft of air and also the fresh air comes in. This is called win-win. Both the people are satisfied. Something which looked to you, there was no solution to it. One says close the window, the other says open the window. Now, this is what negotiation is about. We look to their underlying interests. We'll talk about, I'll tell you in detail a little later. So any one approach to negotiation clearly will not work in all situations. I mean, you can't have a standard rule. You know, when we talked about playing it by the rules, there are rules, yes. But every negotiation which you conduct, you will find has to be handled differently. You have to determine a framework to decide the strategy that will work in different situations. Now, the best strategy there can be a relationship outcome. Now, you may be negotiating every day, but you're not really aware of the skills or have skills that are required to do well. You could be a soft negotiator. Now, here you want to avoid personal conflict and would rather make concessions easily to reach an agreement. You may come to an agreement, but end up being exploited and feeling bitter. Now, let me give you an example. Let's say you are working on a project, which is very important and you need to finish it and submit it by tomorrow. Your friend wants to take you out for a movie and you do not want to say no to him. You go to the movie with him, but on returning, you find that you are left with only a few hours to finish the project. You work through the night and are exhausted and you find the project not up to the mark as you would want it to be. What did you do? Here you gave more importance to the relationship outcome between you and your friend. Now, let's take this another situation where you can be a hard negotiator. You see every situation as a contest. You argue for your position and seek to justify why you going out for the movie is not a good for you, while it's not a good idea. While your friend insists on going, it exhausts you to explain why you can't go at that expense of harming the relationship. You are torn between saying no and yet not displeasing your friend or harming your relationship. Finally, you stick to your position and want to perform well in the project and you say no for going to the movie. Now, here you preferred the substantive outcome over preserving or harming your relationship with your friend. In negotiation, there is another way of dealing with things, which we call principled negotiation. Now, principled negotiation shows you, I mean, in the case of the librarian, how you can obtain what you want, what you are entitled to, and still be decent about it. It enables you to be fair while protecting you against those who would like to take advantage of your fairness, like the the soft bargainer. In this case of your friend. Now, how do we do it? Now, that is what mediation training is about. You need to acquire these skills. But this game can be changed, when we negotiate on merits rather than through a haggling process, where haggling is only about pecuniary advantage. That's what I told you we do in the market. We need to focus on creating value. When we negotiate our interests, they are likely to differ. We may have some of our interests more than the others, right? Why was it so important for your friend to see the movie on the same day? Was it possible to see the movie over the weekend? You could have offered a, dinner along with the movie to your friend. If your friend helped you with the project that day, there are myriads of options that are available. So this is how you create value when we talk of negotiation, which is, the notion in negotiation, the word used is synergy. Creating value means creating synergy, which is the notion that whole is greater than sum total of its parts. That's what synergy is about. So we need to change our mindset. This is where you play the game. Now you said about a science. When you play the game with the rules, learn and acquire the skills, which are very scientific. But how you play the game is an art. It's like playing a piano. When you learn playing a piano through a certain set of keys and rules, you find it so difficult. But once you learn them and you start playing it from the heart. That is what the art part of negotiation is. Once you learn those rules, you really, really will enjoy negotiating. And, you'll get rid of that fear.
Definitely. So I think that was a beautiful example, how the keys of a piano are essentially the rules, because the keys make the same sounds for everyone. But it is how the person applies his or her mind and then uses those rules or the keys of the piano to really produce art or come up with a result. And I think also how you elaborated about the position and interests of parties was very important, because essentially it is the root cause that needs to be solved. And that is something that mediation is very, very successful at doing. It really allows the parties to share what the root cause of the dispute is. So, having understood what negotiation is and how it works, I think we are all very curious as to understand more about the process in itself. For example, now we talked about positions and interests, but how do we begin by starting to understand our client's interests, and how do we help our client distinguish between interests and positions? Because at the end of the day, we humans, we are emotional, and at times we wish to stick to our position, be firm with our position. But how do we really distinguish between interests and positions and help our client understand this difference between the two?
First of all, let's try. As you rightly said, first, let's see how we can distinguish between positions and interests. Positions are ordinarily the demands made by parties. Like, I want a raise in salary. I want my money back. These are demands that you make. Interests, they say, are the silent movers behind those positions. They can be needs, they can be hopes, fears, concerns, desires. They actually motivate people. Position is something you have decided upon. Sir, I must file this suit. Now, that's the position that you've decided upon. Interests are what caused you to decide. Why should you file? Why do I want to file the suit? Are my interests. Now, let me take you back to the wise librarian's example. The initial position of the parties was, while one wanted the window closed, the other said he wants the window open. But when he asked those questions, why? That he could come to know that one wanted fresh air, the other wanted the draft to be stopped so that his papers don't fly. Right? It's only then that the librarian comes to know the real interests of the parties and is able to satisfy both of them. Ordinarily, conflicts of interest arise because parties perceive that gain for one party may mean a loss for the another. Because they think that we are fighting for the same thing. In a suit for recovery, one man wants the money, so therefore the other man has to give the money. And therefore, one person's gain will be another person's loss. And that's their perception. But remember, there can be numerous types of interest that any given party may have in a dispute. There is often greater latitude in trading satisfaction of one set of interests for another, so that all parties can reach and accept a settlement. See, arriving at interests is like peeling the different layers of an onion. Let me explain to you like this. Now, there was this associate, he goes to the senior partner and says that I want to leave the job. So senior partner asks, why do you want to leave the job? Answer was, because I need more money and you can't give me enough of a raise. The senior partner asks, what's the problem? He says, well, my wife and I just had another child and we need to move into a larger apartment. Senior partner still couldn't get to the real issue. He says, so what's the problem? He says, we can't find one that will suit our requirement in the rent we pay. So what did they do? After coming to the bottom of the problem, they found an apartment which met the interests of the associate. They looked around and that associate stayed with that firm for next 10 years. One of the important skills to arrive at the real interest, you have to appropriately, communicate with the other side, to understand them, and then ask appropriate questions in a negotiation. And a setting in court is totally different from what happens in a negotiation.
Yes, sir. That was definitely true. And this example also that you gave with regard to the employee and how the employee stayed on for 10 more years, that just shows how mediation and negotiation help preserve the relationship between both parties. And as you rightly mentioned, to get to know the other party's interests, the way we communicate, how we form questions, how to form appropriate questions to truly understand the other person's interests and also not make them feel threatened in any way or not make them feel as if they're losing footing in they're losing their ground footing inside this negotiation session. It is very important to know how to form appropriate questions. So how would you suggest the council or clients to form these questions, and how have you done it in the past?
Trishan, as I told you, the setting in mediation is totally different than what happens in court.
Right.
Now, questions, to get at interest can be like this. What is important to you? Can you help me understand why that is important? What concerns you about the situation? How does this, what the other party is saying, affect you? So when the other party makes a comment, so you say this matters to you a lot. Is that right? Is there something that you think the other party doesn't understand about your situation? No, all these questions will get you to the position why that other party is taking a hard position and not acceding to what the other person is saying. In the questioning skills, what we say that you follow, there's a funnel approach. First, in mediation, we ask open-ended questions. Now that gets us a lot of information. What brings you here? What happened on that date? These what questions? These are open-ended questions. Unlike in court, we ask close-ended question, answering yes or no. So first we ask open-ended questions to get information. Then after we collect that information, there are certain areas maybe you like some clarifications to be made. So on those narrow specific areas which require elaboration, you can ask questions as to, you just told me about this particular incident. Would you like to tell me something more about it? So these are clarificatory questions or something which we say follow-up questions. And then in the end, you ask close-ended questions. Now, have I understood you correctly? This is exactly what you want? He'll say yes or no. So this is called a funnel approach. Open-ended, you're narrowing down wider, narrower, and narrower questions. Right? That's the approach that we are taught. And I told you also about the kind of, you can ask questions which will get their interest. Now, there are two very important purposes which are served by questioning and mediation. In which direction the conversation moves will be determined by the questions that you ask. You can monitor the progress through your questioning skills, which direction that you want the whole thing to progress. And the second is, the final outcome of the conversation will also be determined by your question. You can lead the parties to a settlement, or you can lead them to an impasse. That is non-settlement, depending on how you ask the questions. See, if you have no knowledge, sometimes, we have a debate on the question of, should we have knowledge only about the process, or should we also have domain knowledge? And we firmly believe that unless you have the domain knowledge, your questioning skills will never be appropriate. You would not know. In a matrimonial dispute, what kind of questions are to be asked? In a commercial dispute, what kind of questions need to be asked? Depending on what the facts are. So therefore, you must have domain knowledge. Now, you see, there are some things which you need to be very careful about. You must ask questions after carefully planning. As you prepare yourself in court, in mediation also, please ask questions after very carefully planning what you want to ask. If you ask a question, don't answer it yourself. Let the party answer. See, there are times when the party is silent. You ask something, please help me understand. Uske baad kya hua? What happened thereafter? You'll find that the party suddenly, you feel is clammed up, and you ask another question. See, the party may be really thinking how to respond. Silence can be a very, very powerful tool. Let that party think about the answer and do it. Don't ask another question. Then, on one point, ask a specific question. Never ask multiple questions in mediation. And remember, your question must be very clear. There should not be further different questions to clarify the question that you ask. No, these are things which you have to be very careful. And as I said, these questioning skills are totally different than how you question in court. Does it answer your query, Trishan?
Yes, sir, I think it does. And this was all very interesting because knowing how domain knowledge is important, of course, domain knowledge plays a great role in also helping one formulate the questions. And as you earlier mentioned, giving the other party space to answer the question, a little bit of silence, how that plays a great role. I think essentially what is very important is making the other party also feel heard in a way. And then that really allows them to open up. So would that also be a right way to put it regarding soft skills in mediation?
Yes, ultimately these questioning skills are so important that they relate to, you will be able to actually come to know as to how parties are reacting to a particular fact situation. Their body language will show to you that how a party is responding to that particular question. Therefore, it is important that you ask proper questions and wait for answers. Because unless you are able to get the party's perspective, because ultimately it is parties' dispute. See, parties, we don't get court papers from the court. The information is asked and acquired, as I told you, through open-ended questions from the parties. And then ultimately you lead the parties to a particular direction.
I'm sorry, sir. I think there was a slight internet issue. I lost you there for a moment. Am I audible now?
Yes.
All right. Sorry about that, but I think it's one of the challenges whenever we are hosting these online meetings. Yes, so moving on to the next question. when we are in the negotiation session and suppose the other party is giving us a lot of offers and there's a lot of information to process and take in, then what is the importance of maintaining a calm mind, a poker face, and thinking before we truly respond? Essentially, what is the importance of using your rational over emotions, not letting your emotions overpower your entire thinking process?
See, when we talk of rationality, we are looking for a decision which parties take with complete conscious understanding as to what is the best for them. And what happens, mostly emotions get mixed up. As after all, human beings are not computers. They are full of emotions. And when I say they are full of emotions, the real merits of the dispute sometimes gets mixed up with the emotional part of. And unless the emotions are taken out, they stop, they don't do rational thinking. And when I say we are creatures of strong emotions, the reason being that we have radically different perceptions and I have therefore difficulty in communicating clearly. And especially in a bitter dispute, feelings may be more important than the talk. Emotions on one side will generate emotions on the other. Fear may breed anger, and anger fear. And emotions may quickly bring a negotiation to an impasse or to an end. And what the problem is, when once emotions get involved, effective listening stops. Let me tell you that in some cases, no agreement is better than reaching an agreement. That is not in the negotiator's best interest. Our natural decisions and negotiation process contains biases that prevent us from acting rationally and getting as much as we can out of a negotiation. Now, there are several biases, but let me explain one of them to you. One of the biases is, what the negotiators make those cognitive mistakes are. Negotiators tend to be overtly affected by the frame or the form of presentation of information in a negotiation. The manner in which negotiators frame the options available in a dispute can have a significant impact on their willingness to reach an agreement as well as value of that agreement. Now, let me explain this to you with two examples. See, you go into a shop to buy a pen. It's worth 100 rupees. And while the salesman is, showing you those pens, a friend of yours passes by and says, look, this pen that you're looking at here, 2 miles down, there is this particular good shop. You can get this for 70 rupees. Right? Now, question is, would you buy the pen from because you know that is also a good shop and the shop where you're standing is also a good shop. Would you buy the pen from that particular shop, or would you walk down 2 miles or go down 2 miles to buy that pen from the other shop? Now, let me change this situation a little bit for you. You're looking to buy a video camera, which is worth 5,000 rupees. And similarly, a friend of yours, while the salesman is taking out the cameras, visits you and says, look, this video camera is available in the shop 2 kilometers down the line, and they are giving it to you for 4,900. Would you buy the video camera for 5,000, or go down and buy that camera for 4,900? See, when studies were made, they found 90% people, in the matter of buying the pen, would go down and buy that pen from the other shop. But when it came to buying the video camera, 50% would buy the camera from the same shop. Now, do you know the reason why? It's not because, you see, in 100 rupees, when you're buying, 30 rupees is about 30% of the price. When you're buying a video camera, a 500 rupee or 100 rupee discount is not that particular percent. But the frame is not the value that you save, because you're saving the same amount, maybe you're saving more in terms of buying the video camera. But is it really worth your time to go down 2 kilometers for purposes of buying that pen or that particular video camera? That is the consideration. So the frame, the manner in which you put the settlement proposal makes all the difference. And these are one of the, so therefore, when you want to exercise rationality, there are so many factors that come in between. And one of them can be your own biases. You see, one of them can be your, idea. The reason why parties want to, you see, you need, you file a suit for 100 rupees. The man says, look, I'm in a position to give you 50 now, but I cannot pay you more because of the COVID situation. I'm not earned so much. Would you accept those 50 rupees or wait for a decree to happen, and then maybe you're not in a position to execute the decree because the man may have disappeared, his assets may have disappeared? Here the buyer sees, they say, you will never gamble for a certain gain. If you're getting 50 rupees upfront, you may haggle with him. Okay, fine, pay me those remaining 50 over a period of 2 years, give me some interest, etc. That's fine. But you will not like to lose that 50 rupees. For a certain, in court, there is no certain gain. But when you, let's say somebody gives you money and says, look, fine, take the money or take a lottery. You will accept the money, then the lottery. Because lottery is you don't know whether the lottery will materialize. So what I'm trying to tell you is these are our biases. When you talk of rational thinking and emotions getting mixed up, rationality itself is dictated by so many personal biases that people have. They're stereotypes, biases, perceptions, which stop them from acting rationally.
Yes, I think that was definitely a very important point with regard to how the offer is perceived, how the offer is made. Because only when the other party feels or thinks it to be valuable with respect to their time, their resources, etc., will they even consider it, and how people will go to 2 kilometers away to save 30% on a pen, but won't go 2 kilometers away to save a larger amount, but a smaller percentage on, let's say, a more expensive product, really explains this difference between how someone can perceive something very differently in two different cases. So, of course, all this leads to one question about what essentially then makes a negotiation successful. Yes, perception about the offer is one key factor into whether the negotiation is successful or not. But in your opinion, sir, what is something that makes the negotiation successful, and inversely, what can add more friction in the negotiation? What pointers should we keep in mind to minimize any sort of friction in a negotiation?
See, As I told you, each negotiation has its own nuances. Sorry. And so therefore, laying down a standard rule, I personally feel if you apply those principles and the skills that you have been taught when you do a 40-hour training and you apply them properly, negotiations work. But if you do not apply those principles, then you are bound to land up in an impasse situations. And, you can make the situation worse. But there are some instances, they say like, some cases actually negotiations don't work. And let me tell you those scenarios. See, let's say when you are totally sold out, you are selling a ware and it's selling like hotcakes. Do you think you will deal with a customer to lower your price? Rather, you would rather raise your price. So when you are totally sold out, you're not going to negotiate. And also remember situations when you know that you are surely going to lose your shirt. It's a total lose situation for you. You would rather not negotiate and choose some other option. See, for some people, when they know they don't have the money to pay, they want to buy time. They would rather go to court. They are not going to sit and negotiate because they don't have the money to pay. So he would choose some other option. He would not negotiate. In some situations, if you don't really care, there's a small, you stop at a red light and somebody comes and brushes your car from the back. You don't think that it's really worth your time. And, you feel in Delhi, everyone today, like there's so much of traffic. You do get your car brushed aside, side, and you would not actually really be interested in negotiating or standing at the roadside and, talking to the person who rubbed your car on the wrong side. So you really don't care. You don't want to negotiate in this situation. Some situations where the demands are unethical. You don't negotiate if your counterpart asks for something that you cannot support because it's illegal or unethical or morally inappropriate. Because your character or reputation is compromised. You lose that in the long run if you make such settlements. See, and on in cases when you don't have the time, if the time pressure works against you, I'm sure you will not be interested, because you will, if you do things in a hurry, you will make mistakes and may fail to consider the implications of the concessions that you make at that time. When parties act in bad faith, don't negotiate. Sometimes waiting can improve your position. You'll have a new technology coming in. Maybe your financial situation will improve. Another opportunity may present itself. Don't negotiate. And the most important part is when you are not prepared. You see, most of the negotiations fail because people don't prepare themselves. Because if you don't prepare, you will think of all the best questions, responses, and concessions on the way home. I could have done this. If you are not ready to say no, there is no substitute for adequate preparation. See, they said, in principle, preparation for negotiation should actually lead you to a plan, which is simple, specific, yet flexible. And they say when you go into a negotiation without preparation, it's akin to negotiating with your eyes closed. And remember, what is communicated in negotiation, 7% is only verbal. 93% is body language or demeanor. You may accept an agreement which you will regret later, which you should not, which you should have rejected, or reject an offer which you should have accepted. Now, when I said preparation is very important, there are three things which you need to remember in preparation. You should cover 3 P's. First P, purpose. You must be clear on the purpose of the negotiation, that we are really interested in arriving at a settlement. That's our purpose when we are sitting to negotiate. There should be a plan. Their reasons, our reasons. What are the creative possibilities? What settlement? How to settle? All that you should actually note down. And the third P is pace of meeting. Whether the meeting should be concluded in 1 hour, 2 hours, how much time do you have? Keep that in mind. So for preparation, remember 3 P's: the purpose, the plan, and the pace of the meeting. Then another thing which is important to succeed in negotiation is your opening statement. The opening offer is very, very important. They call something like an anchoring bias. If the opening offer of the other side, made by the other side, is too small, you are in for a difficult time. It's going to take a long pace, long haul in order to come to a settlement. So in order to come over that anchoring bias, you should make your first opening offer. So making of the opening statement is so important. Then even the physical arrangements are important to understand, when negotiations fail or succeed. See, ordinarily, if you see the rectangular or a square table, parties will come and sit on the opposite side. They will never sit on the same side, right? Now, what does that indicate? It's showing you a head-on confrontation. But when you sit on a round table, see, there are no corners. So in a way, everybody is sitting on the same side. So you're not really opposing each other in that sense. So sitting arrangements can make a difference. Size of the table should not be too small or too big. All these things which you need to take care of. Then you need to have a flexible approach. And which can only happen when you do extensive preparation. Be ready to change. Employ different skills depending on different situations and who you are dealing with. Keep your overall goal in mind. But refine your tactics as you listen to the other side. And learn more about their point of view. Have an idea of your best and worst case scenario. Finally, as I said, what is one very important thing? That you should be able to get up and say no. If you do not have that, capacity to leave the table, you are bound to suffer a loss in a negotiation. And this, is very well explained through an example. This person says his daughter wanted to buy a car. She went to the car showroom and came back telling her dad, the salesman quoted a particular price, and he came back and said to dad, I am really in love with that car. I want to buy that car. You know what the father said? If you really want to get a deal on that car, then learn to say no. Because once you are stuck on buying the car, you'll never be able to make a good decision. You should have the capacity to say no and get up. Now, these are various things, Srishan, these are just small, few of the things that I just told you. We discuss all these things in detail when we do a 40-hour training. But these are some of the tips that I told you that, where in circumstances in which you should do a negotiation and how you should prepare yourself for a negotiation so that it succeeds.
I think this was the first very informative with regard to the preparation and how to prepare also. The 3 P's that you mentioned was that every negotiation should have a purpose. There should be a plan, which is all the creative possibilities, etc. And the physical setting and the and the pace of the meeting, which was there. And again, so as you said, preparation is what leads to flexibility, because only when we are prepared for all the scenarios, all the possible scenarios, can we be flexible and can we ourselves shift from one strategy to another as per required. Then again, something that I found very interesting was the physical setting, whether there's a round table, a square table, because essentially, since negotiation is something between people, psychology plays a very important role. And all these small changes can also have a huge impact on the entire outcome. Um, so, having discussed a little bit about the process of negotiation now, I think it is only fair to come to a very question that has been in high demand. So, with respect to the council, how does the council convince the clients to attempt to negotiate with the other party? Because many a times, if a party hears their own lawyer telling them that okay, we must try to negotiate, then they might perceive the entire situation as if they have a weak case in court. So all these factors also do play a role. So how would you go about this?
No, Trishan, first let me tell you what the role of a lawyer is in mediation. Because traditionally, lawyers are rivals. For lawyers, the way to resolve disputes is based on rights and law. Only court can decide. They are trained and experienced in adversarial advocacy. They perceive it as a division of a fixed pie, and they want the larger piece of the pie for their client. That's technically what happens in courts. But in mediation, remember, parties are decision makers. The responsibility for the outcome stems from their right of self-determination. So now what is the role of the lawyer? Lawyers in mediation, before, as you rightly said, that what they should do, they should actually encourage parties to resolve the dispute through negotiation. Why? And that can only happen if lawyers are themselves trained. Unfortunately, lawyers are not, if they are not trained, their mindset remains as an adversarial mindset. They should actually explain the appropriateness of negotiation or the mediation process to the disputes to the parties, advise them on law and rights appropriate to the dispute, inform parties about the advantages of mediation or negotiation, and then prepare the parties for the process. See, the lawyers prepare parties when they go in for, they go into the witness stand in court. They are told everything, they are prepared and then brought to the court. Similarly, in mediation, before the mediation process starts, it is important for the lawyer to prepare the parties. If the parties are told the advantages of mediation, probably they may not perceive it as a weak case. And during the process, the role of the mediator must be to maintain supportive and cooperative demeanor. Parties, find it difficult to talk. What happens between the parties, the communication breaks down. Mostly when in litigation, you will find in a courtroom setting, one looks east, the other looks west. Even they may be neighbors or family members, but they don't even look at each other in court. What has happened is the communication has broken down. So he helps them to facilitate, discuss the matter before the mediator, assist them in uncovering their underlying interests. See, it is important that the mediator must understand what the interests of the parties are. Let's say the mediator is not in a position to get them and the parties are not willing to talk about it. The lawyer must help the parties and let the mediator understand what those underlying interests are. Then help them in protecting their interests also, that they don't get exploited. That's again the role of the lawyer. Assist them in communication. Assist them in generating options. You see, in court, what happens? There's only one set of relief that can happen. Either the suit gets decreed or the suit is dismissed. The petition for divorce is allowed or it is dismissed. These are the two options that can happen. But in mediation, you can generate several options to us. Several solutions can be found to the dispute. So he assists them in generating options, helps them in evaluating those options, whether the options that they are asking for, let's say, is the price of the house that the man is asking. Is that the price that you will get in the market? He prepares the party and tells them, look, this is not the money that you will get in the market. So when you're negotiating with the buyer, have that reality test in mind. Look at the market price. This is again the role of the lawyer. And then at the end of the day, how to draw up a settlement. It must be an efficient settlement. It must be a legal settlement. And then also help the parties in enforcing the terms of the settlement. So these are various roles that a lawyer plays. So lawyer must shift their role from advocates to advisors in mediation. Here, lawyers do not speak for their client. Instead, they offer advice, guidance, and information. Most importantly, they bring that reality check in their perceptions regarding strengths and weaknesses of each other's case. See, how does the other person think about his case? How does he think about your case? See, because all these discussions happen in mediation. That is the process of self-empowerment. That is the process of consciousness, so that parties can have an informed consent. When they ultimately decide to settle, they should understand. They should be conscious of their legal issues. They should be conscious of their strengths and weaknesses, and then take a decision in the matter. So this is the important role that a lawyer plays.
Yes. So from what I understood, I feel that the role of the lawyers is a slightly more technical role in the entire process, where the lawyer can inform the parties whether this particular solution is good enough, something that they can is sustainable, something that they can accept, and also protect the rights of the parties and help generate more potential solutions. So, of course, the lawyers, they must be going through a lot of training for this, and also they need to understand when to use the help of the mediator and how to inform their client about all this. So, with respect to using the mediator in cases where there's a slight power imbalance in between parties, so how would you suggest, or how do you, in your experience, how have you seen lawyers do that?
You see, power imbalance, so far as when we talk of a mediator is concerned, the moment he starts thinking in terms of power imbalance, he's actually applying his own judgment. When he sees a general manager of a company and a workman on the other side, automatically the mediator thinks that, here is a man who's an English-speaking man, knows all about his rights. Here is a workman who has actually no knowledge about the rights. So how is he going to negotiate? But question is, a mediator is supposed to be neutral. The moment he starts making these judgments, he loses his neutrality. It's not that, after all, a mediator is also a human being. It's not that these judgments or biases won't come in his mind, but he needs to suspend these judgments. Because how does he know that the general manager is actually going to use his power to exploit the workman? Maybe he needs the workman. The man is come to settle the dispute. He's not even come to exercise that power. He's really come to help the workman and make a settlement so that he gets the workman back into his employment, because he's a good workman. So forming a judgment, excuse me, can be completely wrong. Sorry. When we have seen instances, where father-in-law, husband on one side, and you have the daughter-in-law and the wife on the other side. You may form a judgment that, father-in-law is more powerful The husband is a man that is trying to subjugate the wife, and therefore probably she's not in a position to actually protect her rights or state her position. But remember, how do you know? Maybe she's very happy with that situation. Maybe their disputes are something totally different. Unless the party tells you that the party needs support for purposes of taking the right decisions, I don't think that it is for the mediator to form a judgment of power imbalance. So far as the lawyer is concerned, I'm sure lawyers should participate. You see, we have seen this, that in mediation, usually they leave their clients, the lawyers leave their clients and go away, thinking it's a parties who have to decide, and they go away. But if a lawyer perceives his client is not in a position to, negotiate, to balance that power, he should stay and, protect those rights in the mediation process. He can balance that power by participating himself in the process. He can empower the parties by telling them what the position of law is and what kind of settlement to expect in the negotiation or the mediation process. But so therefore, it is a very, very, lawyers, of course, they are representing parties, they can make their value judgments and they can support their parties. But when it comes to mediator, unless the parties ask for it, he should not exercise that judgment. Even if he gets some ideas, he should hold back.
Right, sir. I think it is now, we understand why the mediator really needs to be absolutely neutral and not make any sort of judgments, because it's very important to first completely understand where both parties are coming from and what essentially is their main motive. For example, in the example that you just gave with regard to the labor worker and the laborer and the businessman, we have to see what the main motive of the businessman is. Most probably there is chances that he's simply trying to get the laborer back on his job.
Krishan, this will only come to you by asking right questions.
Right.
If actually the party is not empowered or party is not in a position to hold up, or when you feel that the other party is, trying to suppress or oppress the other side, unless those situations arise, you should not form your own judgment.
Right. So now, so moving on to our last question before we move on to the questions from the attendees. Given the current situation with respect to the overburdened courts and the upcoming mediation bill, how do you see ADR shaping in India, but in particular mediation too? And what is the potential that ADR has in India? And if you were in the law minister's shoes, what steps would you take to ensure that the practice of ADR flourishes?
See, under the new law, they had recommended, before this report of the committee has gone, there was a recommendation that mediation should be made mandatory, before parties. And there is a good reason for it. If you see, the Commercial Courts Act already has a section 12A, which makes it mandatory to, and nobody stops parties from going in for a interim urgent relief. Even the act which is proposed has that provision. Some do argue that it, actually prevents or access to justice. To my mind, the maximum period which is now under the new law which they are proposing is 6 months, within which the mediation has to be concluded. In 6 months, even pleadings don't get completed in court. And when 60 to 68% matters get resolved, thus our statistics in the Delhi High Court are getting resolved through mediation. Why not attempt mediation? See, I think we need to understand, mandatory mediation does not mean that you have to settle in mediation. You have a choice. That choice is yours. The selection of mediator is your choice. Whether to mediate or not mediate is your choice. Whether to accept a settlement or not to enter into a settlement is your choice. All that it says is go and try mediation. You see, today, as you said about the scope, we are looking at peer mediation. We are looking at community mediation. There are several disputes which at the level which need not go to court at all. And all those disputes, neighbors disputes, boundary disputes, all those disputes, can be resolved through mediation. So and today, one of the reasons why courts are, clogged or overburdened is primarily because every litigation which should not be in court lands up in court. And I see a lot of scope. I see that ultimately mediation is going to become a standalone practice in itself, besides adversarial. And then also, it helps you in adversarial litigation too. Because we found even judges telling us after they attended the mediation workshops that their whole attitude in court towards a litigant changes. Earlier, see, the right of audience is only to the lawyer. Parties don't even get heard in court. And so therefore, judges now after attending the mediation workshops, feel that why not hear the litigant also? Maybe he has something to say. And the satisfaction that he gets by, see, at the end of the day, what is a person looking? A listening ear, somebody who hears them. Half the problem of most of the litigants is nobody hears them. By hearing, I mean listening. You see, there's a difference between hearing and listening too. And not even listening, actively listening, empathetically listening. They say 90% problems get dissolved in case if you give a patient listening ear to the disputant. And then thereafter he is willing to resolve. Because we just now talked about the emotions getting mixed up with the real dispute, the merit of the dispute. So if the emotions are out of the way, if somebody is willing to listen to the parties, empathetically, lot of disputes will disappear. And then then when I said, see, I believe in human touch. What mediation is bringing about is healing. When we were in America, and the professor who was part of our TOT said, the difference between an American mediator and an Indian mediator. He said the American mediator settles disputes, and Indian mediator heals disputes. So there is a lot of scope. We expect, but what is more important, the reason why we need a mediation law today, probably one is Singapore Convention, because India is a signatory to the Singapore Convention and we need to ratify. And secondly, we need to have, standards. We need to maintain standards of mediation. And that can only be in case, if you have uniform training, if you have uniform courses that are prescribed, so that proper mediators are properly trained and then they handle the process correctly. So for these two reasons, we need but yes, there's a lot of scope in future. And not only lawyers, let me mind you. I mean, as I said, when I talked of domain knowledge, see, there are medical legal cases. There are contractual disputes. There are architectural issues, building disputes, and flat wire disputes. So therefore, it's not necessary only a lawyer can act as a mediator. But yes, you need a lawyer for purposes of drafting efficient settlements which are in accordance with law. At that stage, you may need. And therefore, to have that particular synergy, we believe in co-mediation or joint mediation, where you can have a process expert, maybe a lawyer, and a domain expert who can be a doctor, chartered accountant, engineer, any person in any one of the diverse fields, depending on the kind of dispute that is before them.
I think this does, to a very great extent, clarify as to why ADR is playing such an important role nowadays and what potential it has in India. And as you rightly mentioned, sir, ADR is important for everyone at this point because it truly helps not just solve the issue from a very superficial level, but really helps solve the root cause of the issue and everyone needs it because they can be, as you said, we might need a lawyer for drafting the solution and drafting the contract, but then there are people who in very particular fields also need to have these skills to solve issues in that particular field. With that, sir, I think it's now we can move on to questions that have come from the attendees. So if you would like to add anything, otherwise I can move
Thank
on
you,
to the
Krishan.
questions.
Let's look at the questions because I think we've already overshot time.
Yes, sir. So the first one was, what is the future of mediation and arbitration in India, which, sir, you have already answered. And the second question, second part of that question is, what are the ideal institutions for gaining training in the field of arbitration and mediation?
See, under the Act, there are going to be service providers and institutes which are going to be recognized as the institutes for purpose of training. See, to my mind, looking at when we talk of capacity building, you may do as many trainings as possible, because as I told you, 40-hour training is merely a threshold training. Ultimately, it's the practical experience which you need to have with an experienced mediator, which will help you in the process of conducting mediations. So a joint mediation, of established mediation centers, private as well as court annex centers, can come very helpful for purpose of getting your internships and getting experience as a co-mediator or as a joint mediator.
Thank you, sir. Moving on to the next question. If there is an absolute deadlock between the parties, what could be the best course of action for the mediator to help the session proceed?
That's what we call an impasse technique, impasse breaking technique. You see, when the parties are in an impasse, see, there are two schools of thought. One, say that parties were already in a state of impasse, that's why they came to you for purpose of resolution of disputes. So it's a misnomer to say that parties got into a state of impasse. But then there are techniques which we employ for purposes of breaking impasse. And, some people even say that if the impasse can be broken, were they really in a state of impasse? So those techniques, in detail, we can talk about only when we do a mediation training. Yes, there are impasse situations which can be overcome, but there are situations, when the parties act in bad faith or parties act irrationally, in the sense that they are not really willing to resolve or look at a solution to their disputes. As they say, you can take a horse to the pool, but you can't make it drink. Then the best method is to break up and let the parties explore other options.
Right. You can only do so much, and then essentially it's a party's own choice whether they wish to come to a solution or not. Because again, negotiation and mediation is a completely voluntary process. So the next question is, how do the lawyers in mediating family matters, how the lawyers do in mediating in family matters as a mediator? Essentially, I think the question aims to ask how a lawyer is mediating in a family matter, because I think lawyers are a little more technical and family matters do require some emotional, or as you said, the human touch.
Tishan, the person who's asked the question and others who are here would be surprised to know that 60 to 68% matters in matrimonial disputes are getting resolved. There are lawyers who are today advising their clients, instead of going in for litigation, to go in for pre-litigation mediation. And the matters at the stage of pre-litigation mediation, especially family disputes, are getting resolved because parties are not hardened their positions. See, once you are in court, you have filed a pleading, you filed a plaint, or you filed a complaint. The other party now takes all the more, it becomes all the more difficult for the other party to accept what all you have said in those pleadings. And therefore, it becomes more difficult. But if you try pre-litigation mediation before actually the process starts in court, the chances of success are much more. And lawyers, let me tell you, are today advising their clients to do so.
Yes, so that makes complete sense, because essentially litigation is an adversarial process. And therefore, if you go for mediation before that, there would be more chance of solving the problem, because the relationship is still to a large extent intact, and there's a higher chance of solving the conflict between the two parties that way. So that's, I think those were all the questions. Oh no, we have another question. So do you have time for one last question?
Yes.
All right. So can a mediator, if he finds that the matter cannot be possibly mediated, advise for litigation?
Can the mediator? You see, mediator does not advise give any kind of advice to parties. If the matter is incapable of being mediated, he tells them that this is not the right forum. Now he leaves it to them that advice must come from the lawyers as to what particular, whether they want to go in for arbitration, whether they want to go in for, civil litigation, whether they want to file criminal complaint. All that is left to the lawyers to advise. The mediator only tells them that this case is not suitable for mediation, and therefore he closes the mediation. See, because he doesn't give an opinion. The mediator doesn't give an advice nor an opinion about the matter. And so therefore that is the role of the lawyer.
Right. So with that, I would like to thank you for being a part of this webinar series and spending your valuable time on helping us develop an insight on negotiating, and how it can be a valuable skill for everyone, not just a lawyer or not just a judge. And I'm certain that we will all greatly benefit from the knowledge that you have shared with us today. We would also like to thank all the attendees for the enthusiasm that they have shown for this webinar series. After doing our best to answer all the participants and our own questions, we would like to call the session to a close now. On this note, we look forward to seeing everyone on the next Saturday for the 6th session on institutional ADR. So once again, thank you, sir. It was a pleasure having you here with us.
Thank you so much.
And you have really shared invaluable information with us. So it was an absolute pleasure.
I'm glad you like it. Thank you so much.
Bye-bye. Thank you, sir. Thank you, everyone. Big thank you and stay safe.